This is English shorthand dictation number 267 and the dictation speed is 140 words per minute. Ready? Start. Honorable Speaker Sir, when I go to the background of this bill, it has taken 20 years to frame this bill and bring it to the Parliament. From 1999 to 2002, the government was one of the members of Foundation Board of the World Anti-Doping Agency. Thereafter, the government signed the UNESCO Convention Against Doping in Sports in 2005 and ratified it in November 2007. When we analyzed the bill, the existing anti-doping rules were adopted by us in verbatim without taking into consideration the realities on the ground in India. The bill formulates these rules into a legislative framework. This framework is crucial in the contemporary situation to protect the athletes' rights and at the same time regulate them. The bill empowers the agencies to act on their own belief to suspect any athlete. I would like to draw the attention of the government and of the ministry to the point that this creates an unreasonable arbitrary authority in the hands of agency members to enter any athlete's premises, seize any equipment, device or substance. The bill does not provide any clarity on the protection of the data they procure from the testing or investigating the athlete. These are missing in this bill. The Ministry of Youth Affairs and Sports constituted a drafting committee comprising eminent legal luminaries, prominent sports administrators, renowned sports persons, medical experts, and law enforcement officers from investigating agencies like CBI and Narcotics Control Bureau. The bill addresses the recommendations of the committee report and proposes the amendments in accordance with the World Anti-Doping Agency Code. But the personal data protection is missing, and that is one of the major reasons why one feels that this bill has overlooked that issue. On 16th November 2020, the United States Senate passed a legislation in accordance with the World Anti-Doping Agency Code. It would allow prosecution of doping offenses at international sporting events in which American athletes, sponsors, or broadcasters participate. The United Kingdom also implemented its national anti-doping policy framed on the pillar of World Anti-Doping Agency Code. In one particular case in India, the prohibited substance entered the athlete's body via a cosmetic product. Similarly, in case of another Indian athlete, the banned substance entered his body by medication administered by a doctor specializing in sports medicine. The case went to the highest level and the players were found at fault and were debarred from playing for 4 years. In that scenario, one of the athletes was a tribal girl who belonged to a backward region of the country, and it cannot be fairly expected from her to conduct research on each and every ingredient before consuming a product. This reminds me of the 16th Lok Sabha when I raised an issue in this house about a female athlete from my state, Odisha, who is currently one of the best sprinters of the country. In her case, our society was actually moving against her. I had raised this issue in the House. The sports minister took the matter to the highest level. India fought that case and we won. So in that respect, I would say that this provision will help our athletes to a great extent. My honorable friend mentioned about the standing committee reports. I would say that certain things are still lacking. The standing committee recommended that a mechanism may be laid for selection and appointment of chairperson and members of the board. This should have ensured proper vetting of the person or persons appointed by the central government. Currently, the bill does not provide for a selection process for appointments in the board. The committee also noted that the bill does not make any distinction between minor and major athletes. The World Anti-Doping Code states that the protected class of athletes, which includes athletes below 16 years of age amongst others, may be given reduced sanctions. The committee recommended that the distinction between a minor and a major athlete should be made in the rules to ensure the protective mechanism for minor athletes. I hope the Minister will mention about the distinction between minor and major athletes. The committee also recommended that since an athlete's career is limited, there is a need to ensure that the quantum of penalties is proportional to the degree of the violation. The committee noted that even after the penalty period is over and athletes have resumed their sporting career, they are not considered for national awards. It is recommended that since this is a policy decision, the government should take note of this and examine the issue. Regarding the laboratories, the committee had recommended that such laboratories should be set up in every state and not only in Mumbai, Chennai or Kolkata. It is because a large number of younger people are moving towards sports activities. When we analyze the bill, I would like to draw your attention to certain issues. The first is the qualification of the Director General, and that is not specified. It is said that it will be notified in the rules. Secondly, the central government may remove the Director General from the office on grounds of misbehavior or incapacity or such other ground. This gives a large scope to the administration or to the ministry or to the government because such other ground has a vast scope. One can understand misdemeanor and misbehavior. That also needs to be probed and the person also can explain. But such other ground is something which needs to be deleted from the bill. Leaving these provisions to the discretion of the central government may affect the independence of the Director General. This also goes against the mandate of the World Anti-Doping Agency, which says that such bodies must be independent in their operation. My second point is that the board has powers to remove the members of the disciplinary panel and appeal panel on grounds which will be specified by regulations and they are not specified in the bill. There is no requirement of giving them an opportunity of being heard. This will affect the independent functioning of the panels. Madam, I would like to mention about clauses 14 and 15. In order to ensure an effective and credible anti-doping system, such organizations must be independent in their ability to make operational decisions. I would like to mention about the qualification. The respective acts of the regulators such as Securities and Exchange Board of India, Telecom Regulatory Authority of India and National Medical Commission clearly define minimum qualification and grounds of removal of members, giving power to the government to decide about the qualification through rules and giving discretion to decide grounds of removal will affect the Director General's independent functioning and will go against the mandate of World Anti-Doping Agency. I would like to talk about Clause 11 and Clause 12. Grounds for removal of a member of the disciplinary panel and hearing panel are left to be specified in the regulation. These grounds of removal have not been specified in the bill. Similarly, the bill does not specify any requirement to give members of the disciplinary panel and appeal panel an opportunity of being heard before removing them. Now I come to Clause 11 and Clause 12. The bill specifies the grounds of removal such as conviction of an offence and abuse of position for the members of the National Board for Anti-Doping, and they are also given an opportunity of being heard in such matters. The bill has not specified any requirement to give members of the disciplinary panel and appeal panel an opportunity of being heard before removing them. The World Anti-Doping Agency requires that the members of the hearing panel should provide collective expertise in relevant fields such as law, science, medicine and sport and must have anti-doping experience of 10 years. However, under the bill, none of the members of the hearing panel are required to have anti-doping experience. This should be specified in the bill. As per the provision in Clause 11, the National Board for Anti-Doping in Sports will constitute a disciplinary panel for determining consequences of violation of anti-doping rules. This panel will consist of one chairperson, 4 vice chairpersons and 10 members, about which my honorable friend said that it would be top heavy. My issue is something different. In the absence of the chairperson, the vice chairpersons will form the hearing panel.